Many times a person with cognitive delay or intellectual disability can win Social Security disability benefits based on that impairment. Now there's a listing 12.05 in the Code of Federal Regulations that addresses intellectual delay. There are two parts to that listing. The first part says that if you have an IQ score between 60 and 70 and you have another additional medical impairment, now that impairment could be physical or mental, then you will automatically qualify for Social Security disability benefits. So for example, if you have a 65 IQ and the judge determines that that IQ testing is valid and you have asthma or depression, then you will be likely to get those benefits. The exception is when the judge finds that even though you have that IQ score between 60 and 70, your adaptive functioning does not reflect that low IQ score. I'll give you an example. If you have a 62 IQ, but you live independently, you have a child that you get on the bus every day, that you're able to feed and bathe. Maybe you got a driver's license, perhaps not through a written test, but through oral examination. In cases like that, the judge may determine that even though your IQ scores are between 60 and 70, your functioning level is actually much higher. And in those cases, you may be denied benefits if it's just based on intellectual delay. The other part of that listing says that if you have an IQ score of below 60, then you will automatically get disability benefits regardless of whether or not you have another physical or mental issue. For that situation, the adaptive functioning test also applies, but it's harder for a judge to find successful adaptive functioning when an IQ is below 60. I find that in the cases that I win for intellectual delay, the most important thing is that that person never have a life apart from a very highly supervised environment. So I will win cases for people who have always lived with a family member. They've never lived alone. Or perhaps they've always lived in a group home setting. They've not raised their own children. Sadly, sometimes custody is taken away from them because they can't raise their children. In those cases, I would even get children's services records to show that a psychological examination was done showing that they were unsuitable to raise the child because of their IQ. I'll also, in those cases, get school records that have IQ scores that predate the age of 22. That's very important to show for the listing that Social Security has. And in cases where IQ scores are not available in the written record, I will request for a consultative examiner who's paid for by the Social Security Administration to administer IQ testing. Frequently, especially in children's cases, I will win a mild mental retardation case just based on a person's IQ score that was found in a recent Social Security test.